This is Michael Popok, and it's time for something we call Legal AF After Dark. What's going on in Florida with Judge Cannon and the Mar-a-Lago obstruction, espionage, and classified documents case against Donald Trump? Why is it getting so much press, not for substantive developments in the case, but for the delays that seem to be instigated or run by the judge? Will the judge be disqualified? What is Jack Smith waiting for in terms of filing a motion to disqualify the judge with the 11th Circuit Court of Appeals? And even if he filed it, would he be successful? And would the case against Donald Trump be tried before the November election? These are the questions that we provide answers to. One place, Legal AF. Take a listen.
Let's move on to the Mar-a-Lago document case here involving.
You lead on this one. This is you. This is
before
your
Judge Eileen Cannon. There's really three issues I want to tackle here, and we'll do it in this order. First, let's talk about the new data of this hidden room, this locked room that Trump changed the locks before the search warrant, what that means. Then let's take on this new story from the Daily Beast about Walt Nauta, Trump's co-defendant and body man, his background of seeing how birds of a feather flock together, here, and his past and why Donald Trump brought him on. I think that's illuminating. And then finally, let's conclude with Special Counsel Jack Smith meeting with Judge Eileen Cannon this past week and what that's all about. Let's start with this hidden room, the secret room, the changing of the locks. Popok, I know you did a hot take on this as well. What can you tell us about this?
Yeah, I was a little surprised by it. Now, let me do a quick primer for Legal AFers. You get a search warrant issued by a federal magistrate in federal court on submissions by the prosecutor, which are not originally made public, along with affiants, people that are going to testify about why there's probable cause to believe that there's evidence of a crime located within a certain location, and it's limited. The judge has to, and they spend a fair amount of time in hearings like this, and I know you've been involved with them too, Ben, where the judge tries to come up with the narrowest scope of the search warrant possible so that constitutional rights aren't being violated for search and seizure. And so you can't just go, well, go look for it anywhere you can find it. Go ahead. Anywhere in Mar-a-Lago, go ahead. There's a more detailed molecular analysis by a magistrate judge in order to have that search warrant not ultimately be quashed at the trial court level, at the district court level. And so, but here, the search warrant scope was for all rooms, storage, and otherwise where records could be maintained. It was pretty broad at Mar-a-Lago. And the FBI, after, and this is where the Trump world never gets it right, after a year and a half of voluntary negotiations that went awry with Donald Trump playing hide the documents from the National Archive, and the National Archive finally getting a first wave, but not everything, from Donald Trump, and seeing classified documents in there and freaking out about that, then redoubling their efforts, all voluntarily, all by demand and with Donald Trump. This is before subpoena. This is before search warrant. And then when all that failed and the Department of Justice started getting insider information from people on the ground and in the know in Mar-a-Lago, that what they were being told by Donald Trump, the National Archive, and the Department of Justice was not true, that there were rooms and locked rooms and movement of boxes and video surveillance and then cooperating witnesses, they were like, yeah, no. So they got a subpoena first, which came from a grand jury out of DC, which asked for everything that was classified, national defense information, defined. And that's when Donald Trump's then lawyer and current lawyer in Georgia, Jennifer Little, is reported to have told Donald Trump, because it came out because she testified or gave a testimony to Jack Smith. She told him, okay, boss, if you don't comply with this subpoena, because he was talking a lot about what if we told them that I complied? What if we didn't give him everything? What if we took this position or that position? What if we made things disappear. That was literally what he told Evan Corcoran, one of the other lawyers that was representing him at Mar-a-Lago. And that's when Jennifer Little told him, hey, boss, it's going to be a crime if you don't comply. Literally, you'll be charged with a crime if you don't comply with the subpoena. And then he still screwed around with the subpoena, hid 30 boxes from Evan Corcoran. This is where we get to the search warrant. And then Evan Corcoran was left, with egg on his face because they sent him into Donald Trump apparently staged a room, literally, with his now co-conspirators, De Oliveira, the maintenance worker, and Walt Nauta, the body man, and staged a room and told Evan Corcoran, yeah, go in there. Go in there. That's where everything is. No, you don't have to look anywhere else. Don't look in the locked drawers. Don't go in my desk. Don't come up to my personal residence. Don't go into the locked room underneath the staircase. Don't do any of that. Just look here. And he spent, and I've seen the earlier reporting, he spent 20 minutes, which is amazing, especially given the billing records that you and I talked about earlier. He spent 20 minutes and came out with 38 total documents in a sealed envelope. Okay. And again, because the FBI and the Department of Justice had cooperating witnesses on the inside, they knew that was a lie. And so they went to the magistrate and got the search warrant. This is step 3 in the process. And that got executed in August of last year, a year ago, August. And that was the big, first time a former president has ever had execution of a search warrant to look for things. Now the new reporting is they missed a couple of rooms and they didn't know about a certain thing, particularly that while Evan Corcoran was down searching for documents in the room that they told him to go in, Donald Trump was at the same time having the lock changed on a closet underneath a stairwell, an old stairwell's extra space. A lot of people have them in their homes that had shelves in it that had always been under the auspices and managed by the Secret Service. He changed the lock and kept the key for himself and didn't give it to the Secret Service, a fact that apparently the new reporting is the FBI did not know about at the time they executed the search warrant. And when they got to the locked closet, they were told there was no key for it. And they were like, okay. And they didn't, which is weird given the fact that they were there for hours, 8, 9, 10 hours at Mar-a-Lago, and that there was another room in Donald Trump's bedroom behind a heavy dresser, behind a television that IT workers used. I guess they had cabling back there and other things, but it was another room that never got searched, which is sort of weird. I always thought it was weird. I want to get your opinion, Ben, on this. I'll turn it back to you. I always thought a couple of things were weird. I thought it was weird they never got a search warrant for Bedminster, especially since he was at Bedminster while the Mar-a-Lago search warrant was going on up in New Jersey and Bedminster. They knew that there was an SUV that Walt Nauta drove from Florida to New Jersey with boxes in it at or around the same time. They never got the search warrant for Bedminster. Instead, they went back to Donald Trump's lawyers and asked them to look again. And they went, oh, we found another storage unit at West Palm Beach. And, oh, here's a couple more documents. That's weird. And this new information that there were a couple of locked and secret rooms that they never bothered to look at it's also sort of weird. Now, one last thing. 99% of the documents that they did find, they found in the storage unit, the basement, the office. They found nothing other than an empty folder in Donald Trump's bedroom. So it's not like I think there's a mother lode that was underneath the staircase. Maybe there was, but the fact that professionally in executing the search warrant, they didn't do that is sort of weird.
Well, here's the thing. There's a bit of a disparity of information that we know covering this than other cases because there are a lot of documents that are protected under CIPA, Classified Information Procedures Act. And that was one of the meetings that took place this past week between Special Counsel Jack Smith's team and Judge Eileen Cannon. Under CIPA Section 4, the government, in cases involving classified information, can file a motion to withhold certain documents from their normal discovery obligations in the interest of national security if those documents are not useful and helpful to the criminal defendant, and then there could be some sort of substitution in its place, like a summary of what the document is, or some other description of the document, instead of actually turning over the nuclear, like the nuclear secrets or the war plans. And so Donald Trump's lawyers asked to be a part of the SEPA Section 4 hearing to look through this information. That's just not allowed. Like, SEPA Section 4 says no. Every court to ever rule on SEPA, it's well-established body of case law around SEPA, there's not a single court that's ever granted that request. But then you got Judge Eileen Cannon, was the only judge in history who said that she could assert equitable jurisdiction over the search warrant executed at Mar-a-Lago in 2022, where she was then very quickly overturned by the 11th Circuit Court of Appeals twice. A lot of people are wondering why Special Counsel Jack Smith has not challenged Judge Eileen Cannon to try to seek her removal at this point in time, and why he hasn't filed any appeals in this case with the 11th Circuit. Judge Cannon has not made any substantive order for Special Counsel Jack Smith to appeal, and you really only got one shot at disqualification of a judge. There's a body of case law in the 11th Circuit. It's hard to disqualify a judge for being compromised. And there's one case in the 11th Circuit where a judge basically made 3 wrong orders in sentencing of a criminal defendant, and there the 11th Circuit removed that judge. So I think when this case got assigned to Judge Eileen Cannon, Special Counsel Jack Smith thought, well, it's the 11th Circuit may still give Judge Cannon the benefit of the doubt and say maybe she learned her lesson. And so if you sought the disqualification at the outset, and then the 11th Circuit denied it, you can never really seek it again, because you would seem that you're really just have a vindictive whatever against the judge. So I think Jack Smith said we have to wait until she makes an order. Now, I think Judge Eileen Cannon, her lesson from being overturned by the 11th Circuit was, wait a minute, maybe I should just not make orders. And if I don't make substantive orders, I can't be appealed and I can't be overturned. So she does everything as these paperless orders. And even this meeting with Special Counsel Jack Smith, she set a SEPA Section 4 pre-hearing with the government to determine if she will then allow Donald Trump's lawyers to be present at the SEPA Section 4 hearing, which the answer is no. There's nothing that could take place at this pre-hearing to ever allow a criminal defendant's lawyers to show up at a SEPA Section 4. So what's she doing? She's just kind of, just wasting everybody's time by holding all of these pre-hearings. Jack Smith knows it, but look, at some point, the rubber's going to hit the road, because March 1st, there's a scheduling conference with Judge Eileen Cannon. She's going to have to make some substantive, ruling on the trial. She's going to have to do something before March 1st. So that's what I'm kind of focused on there. And look, she has a May 20th trial date. She hasn't made any ruling on the most basic SEPA issues yet. So how is she going to make any ruling on the substantive motions before the May 20th trial date? So there's no way that could actually be a real trial date. Also, one of the things that Donald Trump did recently was he filed a motion to compel all of these documents. Then Special Counsel Jack Smith responded on Friday and said, what are you even talking about? Like, you have these documents, you have the CCTV footage, you're making up some like conspiracy that you still have some security clearance from the Department of Energy. Like, that just doesn't exist. And like, your motion to compel is frivolous. One of the kind of interesting things too, I thought, from that motion, this opposition that Special Counsel Jack Smith filed to Donald Trump's motion to compel, it talked about the people who were in Mar-a-Lago. And I just found this incredibly interesting. This data, just like a little kind of Easter egg that was in Special Counsel Jack Smith's motion on page 51. It said, of approximately 48,000 guests who visited Mar-a-Lago between January 2021 and May 2022, while classified documents were at the property, only 2,200 had their names checked, and only 2,900 passed through magnometers. So that's just kind of an interesting data point because Trump wanted discovery on these security protocols for Mar-a-Lago, and Special Counsel Jack Smith's like, you control Mar-a-Lago, and here's the data right here. So Jack Smith filed an opposition to Trump's motion to compel there. We still don't have a ruling from Judge Eileen Cannon. And then I'll throw it to you, Popok, in just a moment. But then, we get this information about Walt Nauta, who left the Navy as a chief petty officer to work for Donald Trump full time. He was Trump's valet in the White House. And then it was just kind of weird. Like who is this Nauta guy? Why would he leave his career in the Navy to work at Mar-a-Lago? And here's what we know. When he started working August 2021 for Donald Trump, this is what we knew, that his security clearance had been docked after accusations of fraternization, adultery, harassment, and other inappropriate sexual conduct, including revenge porn. Two people with direct knowledge told the Daily Beast. Allegations came from 3 female service members. Nauta's behavior had been ongoing for years, it is alleged. The woman reported it in spring of 2021, and it talked about how Nauta is alleged to have had these abusive relationships while he was married and assigned to the White House. The revenge porn by Nauta included supposedly compromising images of women that Nauta retained and threatened to make public. So just give you that data point there that was reported by the Daily Beast. Popok, I'll let you get the final.
I'll do it quick on my end. Ben, I don't think you're being fair. How many of the 48,000 people that came through Mar-a-Lago had Q clearance at the Energy Department? I'll just, by asking you that kind of question is the equivalent of the arguments that have been raised by John Lauro and Todd Blanche down in Mar-a-Lago, and they're getting called out perfectly by Jack Smith. I'll leave my analysis or commentary on this. Jack Smith, in his 68-page filing in response, put it this way, just elegant in its simplicity, to Judge Cannon, even to Judge Cannon. They said that there are only 3 questions, that's it, that the jury is going to have to answer in this case about whether he willfully retained documents containing highly sensitive national defense information. 1, whether he and his co-defendants, the Walt Nauta that you just talked about, and Carlos de Oliveira, who I talked about earlier, the maintenance worker, conspired to obstruct the government's inquiry into the records and whether they made false statements to the FBI. That's it. Though that's the 3 questions. And then Jack Smith ended it with this argument to the judge. The jury will not be asked to decide whether the investigation and prosecution of the case were politically motivated and biased. That's it. This is what this case is about. Those 3 issues. Did Donald Trump willfully retain documents that contained highly sensitive national defense information, and did they conspire to obstruct the government's inquiry into the records and make false statements to the FBI? That is the simplicity of the entire case. This case has been made more complicated and more nettlesome and more frustrating and maddening because of 2 reasons. It has a CIPA, Ven's Jam. It has the Classified Information Procedures Act element to it, obviously, because of the very nature of the gravamen of the indictment. And it has a judge that seems incapable, unwilling, or unable to properly handle the procedures around it in a timely and efficient way. But the underlying case, once you get by how do you produce and how you use and making sure there's no gray mail and all of that, and the national defense information for the American people is properly protected and the defendant's right to a fair trial is also preserved, how do you do that, which would normally be already done months ago? The case underneath it is just breathtakingly simple against Donald Trump, thumbs up or thumbs down. Ultimately, whether it's Judge Cannon or the replacement for Judge Cannon, we're going to get to a trial, hopefully, before November. The fear I have is that even though he's a special prosecutor, it's been a special independent counsel, and it's harder to fire an independent counsel than it is a regular attorney general or Department of Justice prosecuting the case. If for the reasons that we started this entire podcast with, all the meteorological reasons that we can't yet anticipate, right, that would be coming into the case in terms of appeals and tracking, and somehow this all gets stretched out. Like we're watching the DC Court of Appeals, 3 judges who are struggling, obviously, with whatever they're struggling with to render their decision, but time is a-wasting. And if that continues and people don't get out of their Ivy League towers and start getting into the real world of the electors, the voters voting for, knowing whether Donald Trump's a criminal or not, one way or the other, yeah, thumbs up or thumbs down, then we get to an election. And if he gets elected, which I don't think based on current polling, although it's early for current polling, that's going to happen. But if it were to happen, could he fire the special counsel and prevent the very trial from happening that we're waiting on? Yes. I don't want to even have that discussion existentially about the prosecution because I just want to get one of these cases tried before November.
Well, look, the Mar-a-Lago case has, I think, a 0% chance of going before.
I agree.
Let me just be very clear. I think it has a 0% chance of going before November. The Fulton County District Attorney case, I think, has a 0% chance of going before November. The Manhattan District Attorney case, I think, has a 85 to 90+% chance of going. And I would put the Washington, D.C. federal criminal case going before still at 65 to 70%, where I would more normally have that at kind of 85, 90%. There's no certainties in any of these things, but I'm still thinking that there's going to be Manhattan District Attorney. Then I think you'll have Washington, D.C. federal case when the D.C. Circuit kind of makes its, ruling, and then we'll see what happens there.
Well, if you like that, you're going to love the full-length curated podcast we call Legal AF. The title is exactly what you think. We do it right here on the 2 million strong MeidasTouch YouTube channel. We do it Wednesdays and Saturdays at 8 p.m. Eastern time, and then on audio podcasts platforms of your choice. If you're already part of our audience, we thank you from the bottom of our pod. But take that clip that we just did, Legal AF After Dark, and use it sort of as a gateway entree. Send it off to your friends and family and people in your life and say, hey, you know that podcast that I enjoy, I've been telling you about? Here's an example of it. Here's a little teaser. And then if you don't know what I'm talking about, that was Legal AF. I am Michael Popok, and we invite you to join us on Wednesdays and Saturdays at 8 p.m. for the full-length podcast. And then the leaders of Legal AF do hot takes to update, make sure we're current, to make sure we're at the market, as they say, every hour on Legal AF and the MeidasTouch network. So until my next Legal AF, until my next hot take, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.